Hello, I'm John Fanburg, managing member at Brach Eichler and chair of the firm's healthcare law practice. For more than 40 years, I've had the privilege of advising physicians, healthcare institutions, and private equity groups on complex healthcare transactions, regulatory matters, and strategic business planning. Today, I want to share insights into what it means to sell your medical practice in today's evolving healthcare landscape, including what to expect, what to avoid, and how to protect what you've built.
Selling your practice to Wall Street. Part 3 of 3. Avoiding pitfalls when selling your practice. Legal risks and key takeaways.
It is also important to understand that after a transaction is closed, if profits do not meet an institutional buyer's requirements, cost-cutting measures may be taken in an attempt to maintain a financial return on the investment. A buyer may not be as sensitive to non-financial issues as are the partners of a privately owned medical practice, nor will they be sentimental toward former partners or staff and seeking their financial goals. Target practices are encouraged to retain the services of an experienced advisor who can assist in countering the expertise of M&A professionals employed by a potential purchaser and who will work to maximize value and minimize risk in a transaction. Besides the valuation issues pervasive in these transactions, the target practice should also be aware of the applicable regulatory issues. It is common for publicly traded or venture capital-backed physician practice groups to enter into management services agreements with third parties that provide a host of services to their entire organization, such as billing and collection, staffing and maintenance, and general administrative services. Because such management companies are often owned in part by non-physician entities or individuals, physicians should be careful not to run afoul of the corporate practice of medicine rules and fee-splitting prohibitions in certain states. For example, New Jersey's stringent corporate practice of medicine and fee-splitting statutes do not permit physicians to share professional fees with non-healthcare professionals. A new practice entity will need to be formed that must be owned by New Jersey licensed physicians. This new entity will in turn employ the selling physician and/or the selling physician's employees. Entering into an agreement to sell or merge one's practice with a publicly traded or venture capital-backed physician practice group is not an easy decision to make, nor one that should be undertaken without careful reflection and analysis. Understanding the nuances of such transactions, particularly the valuation of regulatory considerations that drive them, are critical to negotiating favorable terms and getting back to what matters, practicing good medicine. Thank you for taking the time to join me. If you're a healthcare provider considering a sale, merger, or new partnership, it's essential to make informed decisions backed by experienced counsel. At Brach Eichler, we're here to help guide you through every step of the process. If you'd like to connect, feel free to reach out to me directly at 973-403-3107 or by email at jfanburg@bracheichler.com. You can also learn more at www.bracheichler.com. And I look forward to hearing from you. Be well.